well. I think it'd be quite challenging to work out what you need. All right, ACT property developers. Now, I have been heavily involved in this, this legislation that has been introduced and is actually going to be debated next week and will be passed in the ACT. So this is the first jurisdiction to licence property developers. So once this scheme comes in, which will probably be, it'll probably be the middle of next year or perhaps even the start of 2026, to do property development in the ACT, you'll have to hold a licence. And in order to get a licence, you will have to get a rating report. So has anyone heard of a rating product called iCert? Yep. Anyone from New South Wales will have heard of it. It is a market-driven rating product that has been established with great enthusiasm from the New South Wales Building Commissioner. So it's not mandatory anywhere. Equifax is the only entity that's currently providing this product called iCert. And basically it is a credit rating for building industry practitioners, which looks at how there's different levels of rating, bronze, silver and gold, and then there's stars within each level up to 5 stars. And in New South Wales, the way that the product is used or accepted, discussed, is that if you have a 3-star gold rating for iCert, you're considered to be trustworthy. And there are a number of developers and builders who have the 3-star, the 4-star, and there's even 1 or 2 that have 5-star gold. And it's now becoming a marketing advantage for those businesses. And they're finding that people looking for apartments, these credentials are being promoted quite heavily in order to distinguish themselves from perhaps, the off-the-plan sale, down the road. This one's got an iCert rated developer. And so the iCert rating process looks at things like, obviously, financial credit ratings, but who are the key persons involved? Have they been involved in, say, Phoenix companies? What sort of defects have they had on their buildings? And they look at media reports as well as court outcomes and so forth. Oh, fantastic. Thank you.
Thank you.
And that's how they do the ratings. So in some respects, the rating reports are a tool to try to deal with phoenixing issues in the industry, are quite a good tool, because if you have companies that have phoenixed and left a lot of liability behind there, that will affect a rating. So what the ACT is doing is saying that in order to apply to become a licensed developer, you will need to get a rating from a regulated ratings agency. And at the moment, this iCert product is the only one in the market. But of course, there are other ratings agencies that might choose to seek approval to issue these reports for developers. And so that'll be a primary piece of information for the government on deciding whether to license a developer in the ACT. Yes.
Obviously, you want somebody with good ratings, but the dilemma in my own mind is if you came in as a property developer and had no ratings at all, or they wouldn't license you, wouldn't credit you, so close the market right now?
Possibly, but if you've had no experience, you shouldn't be building large apartment buildings, should you? So if you're a new business, it won't prevent new businesses because they're looking at the key people involved and what their background is. Yes, so it's not going to prevent new businesses, it's going to prevent inexperienced people from being in the industry. Yeah.
Wouldn't it be better to have this? Wouldn't it be better to apply to the builders? They're the ones that do the construction.
So builders licensing already exists in the ACT as it does around the country, and the iCert product is being used for builders in a voluntary market-driven way heavily in New South Wales.
I won't mention company names, but they build a building with one company name, then shut it down 3 weeks later and build another one.
But that's what the rating process looks at, associated businesses. Yes, but they are issuing ratings for builders as well, and they are looking at previous or related entities to the applicant for the rating. It's interesting that you say it's not going to work because it's voluntary, and that was certainly my view when this product was being developed as well. But it's sort of a reverse to the race to the bottom. Once you get a critical mass of businesses that want to get an ICERT rating, when I said before there's 3, there's 4, there's 5, ICERT now, or Equifax now, has builders and developers who've got the 3-star, and they're coming back to try and get a 4 or a 5, because they're actually creating a race to the top for those ones that want to say, I've got the 5-star, I'm not happy with a 4 anymore, I'm going to go away and see what I can do now to improve my business practices and reapply to get a 5. So whilst those that are not trustworthy will never even bother applying, and they will also be a number of people applying for these rating reports who are told in the preliminary discussion, you're not going to get 3, go away, you've got to do these things and come back. So there is this sort of lifting up of standards through this ratings process. But at the moment, as I said, market driven, although because of the way the ACT is dealing with it, it essentially makes it mandatory, because you won't be able to be licensed unless you have a rating report that you can produce. The ACT government has not said that it's going to need to be 3 stars or it's going to need to be a certain number of stars of a, you just have to have one, and then the decision will be made. And it might be that an applicant that presents with a low number of stars might still be given a licence, but it might be very heavily conditioned. They can only do a certain project of a certain value, or there might be other oversight mechanisms that they put in place for those licensed developers. So there'll be a code of conduct. They're also extending the warranties, which also, the only other place where this applies in Australia is New South Wales. So those warranties in Victoria in the Domestic Building Contracts Act that builders are subject to for 6 years, or for 10 in Victoria, beyond, regardless of new purchases that they run with the land. Those will be extended to developers. So the owners corporation will be able to come after the developer for breach of warranties, not just the builder. There's a reverse onus of proof for the first 2 years. So if an owner alleges a defect, it'll be assumed that the defect exists unless the builder can prove otherwise for the first 2 years. And the philosophy behind that is, well, you've just built the thing, you know it better than the owners corporation and the owners who've bought one lot within an apartment, so you ought to know quite quickly whether it's a defect or not, and we'll put the onus on you to prove that it's not.
It's assumed to exist, and it's also assumed to have been caused by the builders.
Absolutely, yeah. Rectification orders. So this is where they have borrowed literally from the RAB Act that I mentioned earlier from New South Wales, and these are the ability to issue rectification orders on both the developer and the builder. And the idea is that these orders are issued during the work, whilst the developer still has control over the property, and that they can be issued to the builder and the developer, and both are jointly responsible for complying with the orders. They can do what they want contractually in terms of passing risk around, and they can go and have a fight between themselves about who should pay for the defects, but they are both required to respond. And the idea is that they ought to resolve the issues and go and argue about it between themselves later as to who pays, and not have to have owners involved in those arguments about who pointing the finger at who's responsible. Interestingly, there is director liability. This is the big kicker. We don't have this anywhere else in Australia. So a rectification order will be able to be issued against a director personally in 2 circumstances, or if two criteria are in place. The first is where the company is folded up. So if you don't want to be personally liable, don't fold your company, don't appoint administrators and step into your liabilities and sort them out. And secondly, you will get the rectification order personally if the project is not covered by decennial liability insurance or something similar. So again, they're not mandating DLI, But they're saying that if you buy that product, which is now available in the market, there's about 150 policies being issued in the New South Wales market, Class 2. It costs around about 2% of the cost of the work. And if you have that over the property and you still end up becoming insolvent or going into administration, the directors will be protected. So it's pretty exciting stuff. I think it's a great model. I know that other jurisdictions are really interested in it, and we'll see how that changes things in the ACT. Of course, all of this, as good as it is in legislation, comes down to how well it's implemented by government. All right. We haven't got any dinner yet, so I might keep going. Do you think, Jeff? All right. Topic number 3, this is the new practice standard for professional engineers in New South Wales. So if you're working in New South Wales and you're registered up there, which means you're working in Class 2s, 3s and 9s, you will need to know about this document. Has anybody heard about it, seen it? Yep. What do you think?
I think it's a good idea.
Think it's good?
Yeah.
Yeah.
Having that registration and, it slows down the process a little bit.
Yep.
The documents have to be done.
Yep. Yep. What about you?
It's going to be very interesting to see how the process of getting clients to engage engineers to implement practice standards.
Yes. So, yes, and that's the whole purpose. It actually allows your profession to... Oh, he said that it'll be interesting to see...
Quick question. Anyone asking a question at any time, don't just throw your voice problem in the middle, throw it to the very far end. So speak right up. So if I'm speaking now, David can hear me down there. If he's got a question, he shouts it out so we can hear it down here. Sorry, Bronwyn,
that's right.
Both ears, but that's how I make it.
Do you want to, could you repeat it again, the answer?
I said it will be very interesting to see how the process of getting clients to engage engineers to follow the practice standard plays out, because the requirements in the practice standard are so far beyond current, I hesitate to call them standards, current practices in the building industry,
yes,
that the fee impact is going to be very challenging.
Yeah, that's a fantastic point, because this practice standard for engineers, a very similar document was produced for certifiers. So there's a certifiers practice standard for Class 2 and there's a certifiers practice standard for Class 1 in New South Wales. The Class 2 one has been in place now for a couple of years, and the case study that I'm going to take you through, we'll see exactly how that's playing out in terms of fees and practices of certifiers. And the intention is for the same recalibration of the way that engineers work and the opportunity for you to revalue yourselves in the market. Because in order to comply with this practice standard, you'll need to be doing a lot more than you're currently contracted to do, which means you'll need to be pushing back on the scope and the cost that people are willing to pay. And so again, it's another aspiration to drive up instead of the race to the bottom, to lift the benchmark. And so if we all have to comply with this now, and you can show that to your client as to why it is that you need to charge more or insist on certain elements of the scope being strengthened, you have it in a document that you can say, well, I can't give services unless I have this now. And that's what's happened with designers, even through the Design Building Practitioners Act, I believe. And it does increase cost. Absolutely it does. Absolutely. And so it should. It's not increasing the cost, it's shifting the burden from consumers and end users who are stuck in a defect rut for decades in some cases, back to the front of the process where it belongs, and in fact reducing the overall cost, even though the appearance is an increased cost up front, and that obviously increases the cost of construction, but it moves the risk away from those most unable to bear it, being the end users. Okay, click. So it will apply from September. It's been out since about March, and it was the subject of an enormous amount of consultation, which is the case with all of these documents coming out of New South Wales. it is a condition of it will be a condition of registration to comply with all elements of the standard, which means that if you breach the standard, you could be committing an offence and you could be disciplined under your registration scheme. And it will also inform how the government audits the work of engineers when they're going out doing inspections. I've got a quote there which I'll read for our colleagues over here to my left. Professional engineers can provide engineering advice on a regulated building, but they cannot make design compliance declarations or lodge documents required under the DPP Act related to those buildings unless they're also registered as a design practitioner in the relevant class. So what's happened in New South Wales is the Design Practitioner Act, which was what created the registration scheme for various designers, including engineers, also requires registered practitioners to declare that the design that they've produced is compliant. And those declared designs then get lodged into the e-planning platform in New South Wales. So what this is saying is that you can be an engineer, but you can't do declared drawings unless you're registered under the DBP Act as a design practitioner. Okay, that's how the two sort of interplay. The most controversial thing, I believe, and you will probably tell me whether I'm right, is that it requires that engineering services be delivered in a manner that is fit for purpose. Now, did you all know that you're actually exempted from producing fit for purpose services currently? No? So under the consumer law, which deals with goods and services, it says there's a general statement in the consumer law that says that you must produce goods and services that are fit for purpose. And that applies to any goods and services, anyone producing goods and services. But in that consumer law, there is an exemption for architects and engineers from producing services that are fit for purpose. Why? So I discovered this. In fact, I was told about this when I was doing consultation for the Building Confidence Report. Someone said, you know, what about this exemption? Why does this exist for engineers and architects? Maybe it shouldn't. And I didn't know what they were talking about. Went away and had a look at it. And I had our research team look into how did this get there? What is the basis for it? What is the justification? Why are you so special that your services don't need to be fit for purpose, but anyone else in the community providing services to consumers needs to be? Anyone think about why?
Engineers Australia asked for it?
Yes, and AIA.
Yes.
Look, the ACL only applied to
Consumer
products.
goods? Well, if it did, you wouldn't need to carve out engineering and architecture, would you? No. So why are we carving it out? Your insurers love it.
Yeah.
They love it. So as I understand it, it's in there because it's been argued that you will create a design, some lines on a page, and you can't be responsible for how that gets implemented. That's somebody else who's building your design, and therefore you can't be held responsible if your design's not fit for purpose, because that will be the fault of the person who actually constructed your design. Yep. So that's the argument. And the government accepted that, obviously, and gave that exemption. And apparently when there was a review of the ACL, this was one of the provisions that was being reviewed. And so there was another round of consultation that my researchers were able to find that was looking at the removal of this exemption, and there were submissions made again about why it needed to stay, and they're not very convincing, I have to say. But in any event, the exemption didn't get removed in that review. So it's still in there in the ACL. And when they were doing this practice standard, my understanding is that this whole question of fitness for purpose was a really big issue, and there was enormous pushback. I've read a couple of articles about the standard, the draft that was put out, where people were saying, you know, the sky's going to fall in, we won't be able to get insurance, this is just impossible. Yeah.
Is there a distinction between...
Speak up, please.
Is there a distinction between compliance, you know, whether you comply with a code or the building regulation, and being fit for purpose? I mean, if something is, if you comply with the relevant code, is it necessarily fit for purpose?
It's deemed to satisfy.
Well, whether it can be a performance solution or deemed to satisfy, but does that make it fit for purpose?
Well, that's a great question, because I think because this was so controversial and the stakeholders involved said, well, you can't just say we've got to give services that are fit for purpose. You've got to tell us what that means. The practice standard actually says that there are criteria. So you have to meet the criteria. So this goes to exactly your point. And these are it that are on the slide.
I mean, we're all used to preparing designs that are compliant.
Yes.
But then when you throw that meaning in, you've got to explain what that means.
Well, according to this criteria, if you do these things, you'll be delivering fit for purpose services. So you must have a contract of engagement that incorporates a design brief. Now that term design brief, I'll talk about that in a minute because there's quite a bit of information in the standard about what that means. So it's a defined term. The work must comply with all applicable legislative requirements, including the NCC. The work must be within an engineer's area of competence. That's not unusual, right? Must take all reasonable steps to coordinate with other designers working on a project to deliver the project. So you've got to coordinate with the other practitioners involved. And you should take all reasonable steps to provide guidance to the building practitioner as appropriate on how to implement the professional engineering work. Now that's a really interesting one because that's about this interface between your design and the construction of your design. So this says that in order for you to be providing fit for purpose services, you have to take steps to ensure or provide guidance to ensure that your design is constructed properly. Yeah.
This NCC, by definition, is what we design to.
Yes, you design to the NCC.
It may not be fit for purpose in the consumer's mind.
Well, that's where the design brief comes in. So you've got to have a design brief.
So if the consumer wants something which we can't design because it's not in the NCC, we can't do it.
Yes. Well, unless you can do it through a performance solution. Yes.
I was about to ask Bronwyn, fit for purpose is very broad criteria, a set of criteria. Now, there's a distinction here surely between the engineer's services and what's ultimately produced from them.
Yes.
Now, if the engineer receives a design brief, design a plastic mule rest will support a mug one. And that plastic mule rest doesn't support the mug one. But he has met all the criteria of the design brief. It's a non-standard mug mug or something. I would suggest his services are fit for purpose. The end result's not.
Yes.
There are more pragmatic criteria by there. Is that reasonable?
Well, I think this is where this term design brief's really important because what is it you're being asked to do? You obviously have to comply with the NCC, but you also need to meet the client's design brief.
You've got Section 28 in the Victorian legislation, which is basically safety and design stuff.
Yes.
And so it's interesting for me because this is starting to catch up with that stuff, which is in every other state's legislation. It's been a long while.
Yes.
And it's sort of being left off the table. So you say you design your mug one, hold up a mug one, but it falls down and sets something on fire as a consequence because mug ones are inherently flammable.
Yes.
Then all of a sudden you haven't met any of those criteria. And that's so often the case, especially with architects got involved in the rollout of that legislation.
So what I'm hearing is this is the reason why fit for purpose has been an issue for engineers and architects, but this seeks to really find a way through that and create an obligation that is sensible.
For me, I was not meant to talk about liberty. I was involved in that rollout of that and developed a whole checklist for architects. And because we got so little traction and so little uptake from architects, because we got so little traction and uptake from architects, I developed a whole tool for them to use. And then we thought, we'll go out and trial this, which was very naughty, because in essence we were consulting back to architects. And I spent a week with an architect, and the pushback I got from him to design something that was designed to be safe
Yes.
or functional or not dangerous was astonishing.
Yeah.
For a week. And he finally went, oh, this makes sense, doesn't it? Oh,
Yeah.
It does make sense.
So this is again an area where you might need to have a bit of pushback now around these sorts of issues, which I think is a good thing. I'll keep going because not everyone's got their meal, but when mine comes, I'm going to sit down when mine comes. Okay. Now the other thing that's really important, I'm going to read this out for you guys. Yep, next slide. So what it says after this criteria in the standard, there's this paragraph. It says, the obligation for the counterparty to accept the professional engineer's advice. So this is that last one about the building practitioner actually implementing your design correctly and you encouraging that. So the obligation for the counterparty to accept the professional engineer's advice and for the contractor to construct strictly in accordance with that design rests with the counterparty and contractor, not the professional engineer. However, to the extent that it is reasonably practicable and they are engaged to do so, it is expected the professional engineer plays a proactive role in all relevant stages of the build process and will attend sites as necessary to see that the work has been carried out in accordance with the designs prepared by the professional engineer. Yes.
You talked about guidance before.
Yes.
Are you talking guidance or supervision?
Well, they've used the word guidance, and I would suggest to you that every single word here has been thought about carefully. So it means guidance, not supervision.
I'm sorry, the Section 28 stuff talks about who signs off on that decision, basically.
Yes.
Which is, sorry, the Section 28 legislation is an example, talks about who signed off on that decision, which that leaves out, if that makes sense, it leaves it ambiguous. So who's responsible for the decision?
Well, perhaps in that paragraph, but there's definitely discussion about certification and the role of the engineer in the practice standard.
I mean, on who makes the decision, which may be, we'll build this big blue thing, and this blue thing cracks and does whatever.
Yeah.
Whoever made the design decision becomes responsible because they've
Oh, yes.
yeah.
I would imagine so.
That leaves it out in that.
That's right. Yes. I'm going to keep going. Another slide. So that's the fit for purpose. On the next slide, I've just got some headings, which are really some of the main topics that are in the guide, and I'm not going to go through all of them in detail, but I do encourage you, even if you're not working in New South Wales, I encourage you to have a look at this practice standard for the reasons that this gentleman said down the end here. It is going to be really interesting to see how the commercial engagements work when you as an engineer say, well, I need to make sure that I'm meeting this standard here, so I can't agree to that scope. I need to, for example, be able to do site visits and inspections at these stages so that I can properly oversee and give guidance on how my design is being constructed. So there is a discussion in there. There's a reference to the duty of care provisions which exist in New South Wales, so a statutory duty of care to owners and that they don't suffer economic loss, and that's being used heavily in New South Wales now as a ground for litigation. Adequate insurance and how it is that you determine what's adequate. The design brief, I mentioned that already. So there is a page and a half or more on what should be in your design brief, what are the elements of a design brief, and that goes, very clearly to that definition of fit for purpose. Independent third-party review, there's some quite good commentary in there on what the role is of an independent third-party reviewer and also how you should receive comments from the reviewer if your work is being peer reviewed. It stops short of mandating any requirement for independent third-party review, which was one of the recommendations from the Building Confidence Report. It does say that further versions will mandate the requirement for independent third-party review in specified circumstances which are yet to be defined. So, but some good commentary in there on the role of an independent third-party reviewer. the obligation on engineers if you're specifying